and 2023 CR 4371B, State versus Moreno Vasquez. Can I have parties announced?
Megan Galloway and Lorna Espinosa for the state.
David A. Garcia, attorney for Marco Moreno Vasquez, Judge.
All right, and we do have an interpreter here. If you can state your name for the record, please, to the interpreter.
Mariana Rios.
All right. And she's previously been sworn. The deputy has informed me that a verdict has been reached in this trial. Are both parties ready to receive the verdict?
Yes, sir.
We are, Judge.
All right, Deputy Laura, are the jurors ready? All right, let's bring them in.
All right, for the jury.
All right, ladies and everyone, please be seated. Ladies and gentlemen of the jury, it's the court's understanding that you've reached a verdict in this case. Is that correct?
We have, Your Honor.
And is that a verdict as to each count?
Yes, ma'am.
And are those verdicts unanimous?
Yes, ma'am.
All right, if you'll hand the verdict form to the deputy, please. All right. If the defendant will please rise. Count one, to the charge of murder, it states, we, the jury, find the defendant, Marco Moreno Vasquez, guilty of the offense of murder as charged in count one of the indictment. Count two, deadly conduct. It states, we, the jury, find the defendant, Marco Moreno Vasquez, guilty of the offense of deadly conduct as charged in count two of the indictment. You may be seated. All right. So, ladies and gentlemen, what I'm going to do is I'm going to have the deputy take you back to the jury room. There are a couple of things that I need to address before we bring you back out. Do not think about this trial again unless you're in the box. All right. Everyone, please rise for the jurors. All right, everyone, you may be seated. State, with regards to punishment, are you planning on having any witnesses?
No, Judge.
Defense, are you planning on having any witnesses?
Judge, the one witness that we called to be here is not here. We don't expect him to show up. So I need to speak to my client to see if he wants to testify.
All right. We'll give you a chance to do that. Is the courtroom next door available? Because he may want to speak to his client in private.
Yes, it is.
All right. So you can speak to your client next door with the interpreter.
Thank you, Judge.
All right. You're welcome. All right. Let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what's called the charge of court on punishment. Again, you do not have to memorize this. The original will be given to you when you begin your deliberations. Charge of the court on punishment. Members of the jury, by your verdicts in this case, you have found the defendant, Marco Moreno Vasquez, guilty of the offense of murder as charged in counts one of the indictment and deadly conduct as charged in count two of the indictment. It is necessary that the jury assess the punishment for these offenses. You are instructed that the punishment for murder, oh, I am so sorry. Please disregard everything I have just told you. State, would you like to make an opening statement?
No, Your Honor, we waive it.
Defense,
No, Your Honor.
state, any witnesses?
No, Judge, we just re-offer all of the evidence that was admitted in the trial.
No objection.
All right, and any witnesses from the defense?
No witnesses, Judge.
All right, thank you. So, ladies and gentlemen, you can tell outside your presence, both parties had informed me that they did not intend to call witnesses, but both parties have now rested and closed as it relates to punishment. Now I can read to you the jury charge. Okay. Members of the jury, by your verdicts in this case, you have found the defendant, Marco Moreno Vasquez, guilty of the offense of murder as charged in count one of the indictment and deadly conduct as charged in count two of the indictment. It is necessary that the jury assess the punishment for these offenses. You are instructed that the punishment for murder is confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. Therefore, you will assess the punishment of the defendant at life or any term of not more than 99 years or less than 5 years for count one. You are instructed that the punishment for deadly conduct is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 10 years or less than 2 years. Therefore, you will assess the punishment of the defendant for any term of not more than 10 years or less than 2 years for count 2. In addition to imprisonment, an individual found guilty of the offense of murder and deadly conduct may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim or victims, if any, but is paid into the registry of the court. With regard to count 2, the defendant in this case has applied on written sworn motion for community supervision, stating, among other things, that he has never been convicted of a felony in this or any other state. Our statutes provide that where a defendant is found guilty of deadly conduct is charged in count 2 of the indictment, and the jury finds that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision during the good behavior of the defendant. If the jury does recommend community supervision on count 2, it will be granted by the court. If there is any evidence before you that the defendant may have committed any act of misconduct other than the offense of which you have convicted him, you are instructed that you may use that evidence, if any, in assessing punishment in this case, but only if you find from the evidence beyond a reasonable doubt that the defendant committed such other act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such act of misconduct was committed, or as to whether the defendant was involved in such other act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, and any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the applicable law in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdicts if you should care to use them. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, each verdict must be unanimous, in writing, and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. All right, we're on the record in 2023, CR 4371B, State versus Marco Moreno Vasquez. Could I have parties announced?
State.
David A. Garcia, attorney for Marco Moreno Vasquez, Judge.
All right, and we have the interpreter present.
This is Chavez license number 2203.
All right, thank you. Let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. Ladies and gentlemen, we have an interpreter here. You've seen him here before. He has taken the oath to translate as well. It's the court's understanding that you all have reached a verdict as to punishment. Is that correct?
Yes, sure.
And is that a verdict on each count? And is it unanimous? All right, if you'll hand the verdict form to Deputy Laura, please. Thank you. All right, if the defendant will please rise. And count one, it states, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years. That's 40. In addition, we assess a $1,500 fine. And count two, it states, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 6 years. In addition, we assess a $1,500 fine and that the defendant's application for community supervision be denied. All right, ladies and gentlemen, Deputy Laura will take you back to the jury room and I'll come and speak with you briefly. Everyone, please rise for the jurors. All right, everyone, please be seated. All right, Mr. Moreno Vasquez, the jury having found you guilty, the court is finding you guilty in counts one and counts two. And the jury's verdict of 40 years in count one with a $1,500 fine and 6 years in count two with a $1,500 fine. The court will enter those as your sentence as well. And count one and count two will run concurrently. And in count one, there's an affirmative finding of deadly weapon. And let me see, could I see the indictment as it relates to count two, please? Ah, thank you. I'll have it there, yeah. No, I was, because you were bringing it. Thank you.
That's count three marked.
Is there anything else with regards to sentencing from either side?
No, Your Honor.
All right. Mr. Vasquez, did you review the trial court certification of defendant's rights to appeal with your attorney?
Yeah, they told me it was for appealing, yes.
All right. And counsel, do you speak Spanish fluently?
I do, Judge.
And have you been able to communicate with your client with and without an interpreter?
I have, Judge.
All right. Then with regards to the trial court certification of defendant's rights to appeal, Mr. Moreno Vasquez, because this was not a plea bargaining case in a jury trial, you do have the right to appeal. All right. Is there anything else from either side?
Not from the defense, Judge, but if we can keep the interpreter here just for a little longer, I'll have my client sign a motion for an appeal.
All right. Thank you.
The proceedings highlight the structured transition from a unanimous guilty verdict to a separate punishment phase, emphasizing the jury's central role in determining both guilt and sentencing under Texas law. Judge Stephanie Boyd carefully safeguarded the fairness of the process by correcting a procedural misstep, ensuring proper jury instructions, and repeatedly reminding jurors to base their decision solely on the admitted evidence rather than speculation or the defendant's decision not to testify. Both the prosecution and defense elected not to present additional punishment evidence, leading the jury to rely on the trial record when weighing the seriousness of the murder and deadly conduct convictions. The denial of community supervision on the lesser offense, combined with a 40-year sentence for murder and concurrent terms, reflects the jury's assessment of the gravity of the offenses. Overall, the case demonstrates how procedural safeguards, impartial judicial oversight, and evidence-driven deliberations remain fundamental to achieving a lawful and balanced criminal verdict.